A Supreme Court decision just landed that could change where you can legally carry a gun in this country. And here's the part nobody's talking about. Every single sensitive place law on the books is about to face a serious challenge. Pause, and if you don't understand how this works, you could be the one who ends up in trouble without even knowing why. Quick question before we continue. Are you subscribed? Because what I'm about to break down could keep you out of a very bad legal situation. Hit that subscribe button right now. It's free. It takes 2 seconds, and it makes sure you actually see the next update when it drops, because laws like these change fast, and you don't want to be the last person to find out. Alright, let's get into it. First thing you need to know, what is a sensitive place law? It's a law that says you cannot carry a gun in certain spots. Think courthouses, schools, polling places, government buildings. The idea sounds simple. Some places are just too sensitive for guns, and for a long time, courts agreed. But here's where it gets interesting. In 2022, the Supreme Court dropped a ruling called Bruen, that's New York State Rifle and Pistol Association versus Bruen, and it changed everything. The court said the government can't just invent new reasons to restrict guns. It has to look at the text of the Second Amendment, plus our history, plus our tradition. That's the test. Text. History and tradition. Let me explain what that actually means. Before Bruen, courts mostly asked one question. Does the law serve a good public interest? If the answer was yes, the law usually survived. But after Bruen, that question is gone. Now the state has to prove something much harder. It has to show that this kind of restriction existed back in our history. Not just that it sounds reasonable, that it fits our tradition. And that is a much higher bar. So now, every gun law has to be measured against what this country did back in the founding era. If a law doesn't match our historical tradition, it's likely unconstitutional. And that's a huge deal for sensitive place laws. Because here's the thing most people get wrong. The Supreme Court has always said there are sensitive places where guns can be banned, but that list was always short. Courthouses, legislative chambers, polling places, maybe schools. That's it. The problem is, states started making the list way bigger. Way bigger. Parks, beaches, bars, casinos, theaters, shopping malls, hospitals, public transit, and that's exactly where the challenges come in. Then in 2024, the Supreme Court gave us another ruling, United States versus Rahimi, and this one clarified the rules. The court said the government doesn't need a perfect historical twin for every single law. But the law still has to fit the principles behind our history and tradition. So states can't just grab some old law, copy it, and slap a new label on it. The reason has to actually match. If the reason doesn't match, the law is in trouble. Let me give you a simple example. Imagine a state says a shopping mall is a sensitive place. Fine. Now the state has to prove that malls were treated this way back in our history. But malls didn't even exist back then. So the state has to find something close, and that's where these laws start to crack. Here's a hypothetical example to explain this. If the only historical rule you can find is about guarding courthouses, you can't stretch that into banning guns at every park in the state. The principle just doesn't fit. Now think about what this means for you. Imagine you're driving to work and you stop at a gas station. You have a valid permit, you're carrying legally. But then you find out the gas station sits on land the state calls a sensitive place. Suddenly, what you thought was legal is a crime. That's the reality people are living in right now. And that's why these challenges matter so much. They're not about some abstract legal theory. They're about whether you can live your normal life without becoming a criminal by accident. If you're finding this helpful, wait until you see my next video. I'm breaking down the exact words to say when a cop asks if you're carrying. Subscribe now so you don't miss it. This is the kind of stuff that actually protects you when it counts. Now this is where it gets really interesting, because the biggest fights right now are about how far states can stretch that sensitive places list. Let me give you a real example. New York passed a law called the CCIA, that stands for the Concealed Carry Improvement Act, and it banned guns in a ton of places. Parks, theaters, bars, and a bunch more. But here's the part that shocked me. One part of the law covered private property, and that part covered over 91% of the land in New York. Think about that for a second. 91%. If a law covers 91% of your state, is that a small exception? Or is that basically a ban? That's exactly the question the courts had to answer. A case called Antonyuk versus James went to the Second Circuit, and in 2024, that court made a big call. It upheld most of New York's law, including the sensitive places list, but it struck down that private property rule because it was just too broad. The court basically said, you can't turn the whole state into one giant sensitive place. That's not a carve-out anymore. That's a ban. And here's the crazy part. The Supreme Court had a chance to review that case, and in 2025, it decided not to. So for now, York's law mostly stands, but the fight isn't over, not even close, because that 91% argument is now out there, and other states are watching. Look at New Jersey. New Jersey passed its own sensitive places law back in 2022. It banned guns in parks, beaches, bars, casinos, and more. In 2025, a 3-judge panel actually upheld the law, but then the decision got vacated. That means it got wiped away for a bigger review. The full court is going to look at it again, so that law is standing on shaky ground right now, and every gun owner in New Jersey is stuck waiting to see what happens. And California? California has a law called Penal Code, Section 26,230. It lists a ton of sensitive places too. There's a case called Wolford versus Lopez fighting it. The Ninth Circuit has already looked at parts of it, and parts of that law got blocked, so the pattern is crystal clear. States keep passing huge lists, and courts keep cutting them down, piece by piece. Every single time, the challenge comes down to the same 2 questions. Is the place historically sensitive? And how much of the state is left if you add it all up? Here's what most people get wrong about all of this. They think these cases are only about the people who filed them. They think I'm not a plaintiff, so this doesn't affect me. But that's backwards. When a court strikes down part of a law, it affects everyone in that state. The rule changes for all of us, not just the one person who sued. So even if you never step foot in a courthouse, these rulings decide where you can carry tomorrow. That's why you need to understand them. Hey, here's a quick stat for you. Most of the people watching this right now aren't subscribed. Don't be part of that group. Join the thousands of gun owners who get these legal updates first. Hit subscribe. It's free, and it keeps you in the loop, because these rulings drop fast, and you want to hear about them before they affect you. Now here's the part nobody's talking about. The biggest win just happened in Hawaii. In 2026, the Supreme Court struck down a Hawaii law that made it a crime to bring a gun onto private property without the owner's permission. Some people called it the vampire rule, because you couldn't even step onto private land with a gun unless someone invited you. The court said that law basically destroyed the right to carry in public, because almost all land is private. So the law was really a total ban in disguise, and the court wasn't having it. So let me break down exactly how every sensitive place law must now be challenged. First thing, attack the list itself. Don't accept the list of sensitive places as a given. Ask the state to prove that each place matches our history and tradition, courthouses and polling places. Sure, a shopping mall? A park? A beach? The state has to show the historical proof, and a lot of the time they can't. Second thing, look at the total burden. This is the trick courts are using now. If you add up all the sensitive places, how much of the state is left? If the answer is almost nothing, then the law isn't a reasonable exception. It's a ban, and bans on carrying in public are unconstitutional. That's the 91% argument from New York. That's the Hawaii argument, and it works. Third thing, use Rahimi the right way. The state will say, look, we have historical laws. But under Rahimi, the law has to fit the principles of our tradition. It's not enough to find some old law that kind of looks similar. The reason has to match, and if the reason doesn't match, the law falls. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. But here's the thing you have to remember. Even though these laws are being challenged, they are still on the books right now, even the ones that courts are questioning. If you carry in a place that's on the list today, you can still be arrested today. The challenge doesn't protect you yet, not until a court actually blocks the law. So while these cases play out, you have to follow the law as it is right now. Don't be the test case. Let the courts do their job and stay out of trouble while they do it. This is the part that really matters. Every one of these rulings is a building block. Each one teaches the next court something. The Hawaii decision will be cited in the next challenge. The New York case will be cited in the next one after that. And slowly, piece by piece, the map is changing. Places that used to be off limits are coming back, but it takes time, and it takes people who are willing to fight. Here's the thing. This legal landscape is changing fast, and the next big ruling could drop any day now. Subscribe now, because my next video breaks down exactly what you need to do before that ruling lands. Don't get caught off guard. Don't be the person who finds out after it's too late. So here's your takeaway. Sensitive place laws are not going away quietly, but they are being challenged, and they're being challenged the right way. Attack the list, show the total burden, and demand the historical proof. That's how these laws get cut down, and that's how your rights get protected. Look, I spent hours digging through court rulings so you don't have to. the least you can do is hit that subscribe button. Deal? Pause, because the next ruling could change everything, and I want you to hear it from me first. Subscribe, turn on notifications, and stay safe out there. One more thing. This video is for education only. It is not legal advice. Laws are different in every state, so before you change anything you do, talk to a licensed attorney in your state. Stay informed, stay legal, and I'll see you in the next one.